ask questions of your HOA and watch what they're doing. A lot of the HOAs don't like being asked questions, hence all these letters that I've received and many others in this video.
I have never harassed my HOA. I have never caused them any trouble. Nothing. I've just been a good, what I think, a good neighbor. It is my understanding that you have recently exhibited harassing and have a history of harassing and threatening behavior. Please immediately cease and desist from any further harassing or threatening behavior toward the board. Further, please immediately cease and desist any verbal or written communication with the board. In the event that you continue to exhibit the above-mentioned behavior, the board will pursue the following legal remedies against you to ensure that your behavior does not continue, including but not limited to filing for formal police reports, documenting your behavior, obtaining an injunction prohibiting harassment against you.
Rather than fix the problems with not following reserve studies, not maintaining the property, not saving money, not treating for termites, they want to say they're going to come after me. This first letter I got says, you immediately cease and desist all unauthorized and improper communications with association contractors and third parties. Be advised that if the association is damaged as a result of any unauthorized and improper communication originating from you, the association will seek to recover any resulting damages from you personally. The association hereby demands that you immediately cease and desist all unauthorized and improper communications. To the extent that you wish to communicate regarding board business, you must first obtain prior approval from the board to do so. Continue to breach your duties, the association reserves the right to pursue all legal remedies available.
Then I receive another letter, August 12th. This letter is placing you on notice to cease and desist making defamatory statements regarding the board. If you fail to do so, the aggrieved parties will pursue their legal remedies against you. The association also requested that I send you a friendly reminder regarding that your front yard furniture, pursuant of the resolution of the board, August 6, 2014, must be removed. Please immediately cease from violating the resolution by removing all furniture, including patio furniture, from your front yard. I have lived in my home for 23 years. I've had furniture in my front yard for those 23 years, and now all of a sudden, I can't have it.
Please be advised that the association has reviewed your inquiries and responded to them. The association will not repeatedly investigate issues. It is my understanding you've repeatedly contacted and harassed members of the association's board of directors, employee of the association's management company, and employees of the association vendors. Please immediately cease and desist from any further written or oral harassment of the above-mentioned parties. In the event that you continue to harass any of the above-mentioned parties, said parties will pursue their legal remedies against you. Please be advised that all future communication to the association's management company, and the association's vendor must be submitted to my office in writing via U.S. mail.
I sent my community property manager email suggesting that we could walk the property together. And instead of a reply email saying, sure, let's do that, I got a cease and desist letter. This letter says, please be advised that you do not have the legal right under Arizona law to communicate with the property manager in any manner I choose. You are entitled to attend the open meetings of the board. At these open board meetings, you are permitted to speak at appropriate times subject to reasonable time restriction. You must immediately cease and desist, all uppercase bold. All email communications with the property manager. Should you wish to address any community concerns, you may contact the property management company in writing via U.S. mail only. All this because I asked that we walk the property together. You know, the thing is, in the last 12 months, I've sent only 9 emails to the property manager. I just want to help keep my community nice and preserve property values.
This one from the management company's attorney, after I stopped by their office to deliver my notice that I'd be videotaping meetings. You entered the office and started harassing the receptionist and other staff. You made disparaging remarks about the property manager. This is not the first time you have threatened the employees and owner of the management company. Specifically, you previously threatened the same manager and owner by saying words to the effect of, "I know where you live." For that reason, we respectfully but strenuously ask that you refrain from coming to the office and stop all communication with its employees, including but not limited to communication by phone, email, text, fax, etc. In the event you show up again, you will be trespassing, and I have instructed the management company to call the police and have you removed as a trespasser. Failure to act as requested in this letter may result in immediate legal action against you without further notice.
After a long time of asking questions at board meetings, being told this isn't the place for you to ask those questions, on November 7th of 2014 I received my first cease and desist letter from the then association lawyer complaining about my sending an email to my neighbours trying to describe what was going on and my side of the story. Well, this letter was sent to my lawyer, but upon information and belief, your client may have logged into the association's website, obtained homeowner emails and emailed homeowners regarding his candidacy for the board, association issues and the upcoming annual meeting. Please be advised that such behaviours and actions are prohibited pursuant to the association's rules as stated on its website. In the event that your client takes any further or similar actions or behaviour, the aggrieved parties reserve the right to pursue their legal remedies against your client. The reality is that the language of the community address book, community website, which relates to the address book, is that this address book is provided as a service to the members of this community. You may edit personal information appearing here under the user profile link on the sidebar. Any information you do not wish to share with your fellow owners should not be entered there. Back to the cease and desist letter, says further, the information in Mr. McMullen's email mentioned above misrepresents the actions of the association's board. This letter is placing Mr. McMullen on notice that if he continues making defamatory statements regarding the association, the board, or individual board members, the association will vigorously pursue a defamation lawsuit against him. This is the association's final warning on the matter. The board members wrongly accused by Mr. McMullen do not deserve to have their reputations dragged through the mud. The 4 individuals publicly maligned by Mr. McMullen's baseless accusations reserve the right to pursue additional legal actions against Mr. McMullen. Maligning of reputations, listen to what they've called me: a terrorist, worse than the ones that behead people, a stalker who brings guns to board meetings, a computer hacker, a thief, an illegal alien. I'm not a lawyer, but I've been accused of being a lawyer who makes his living moving from HOA to HOA filing lawsuits. The backstory to these cease and desist letters that I've received already is that I went and filed 2 lawsuits against my association and board members representing that association. One of those lawsuits was a breach of contract, which the court subsequently found me to be the prevailing party. In a bizarre twist, the court decided to award me 1/3 of my costs. The second lawsuit was a defamation lawsuit where the various labels that were applied to me were found by the court to be not defamatory but hyperbole.
I got a third letter. This one is from the HOA attorney. It has come to our attention that your client's behavior has become increasingly unruly and disruptive. We are informed that Ms. Schweitzer became so disruptive that near the end of the meeting, a police officer who was in attendance at the meeting had to stand up and inform Ms. Schweitzer that he would end the meeting unless she ceased her disruptive behavior. She is not permitted to engage in unruly, disruptive, or otherwise uncivilized behavior at association meetings. While your client may attend tomorrow night's meeting on a probationary basis, they reserve the right to ban Ms. Schweitzer from attending any further meetings in person. Never in my life have I ever gotten cease and desist letters. But apparently, in an HOA, you're not supposed to ask questions.
We're writing concerning your Facebook post of 2 months ago. Here is the post. If you have a choice, don't use this company. They only care about the check that they receive each month and allow their boards to run wild. You're defaming the management company. In addition, by suggesting that they should not be hired, you are infringing upon their profits, damages for which you may be held responsible for. We are writing this letter to demand that you immediately remove this post from your Facebook page. Should you choose to ignore this request, we will be filing a lawsuit against you personally in Maricopa County Superior Court. I urge you to obtain an attorney. I look forward to your response or the response of your attorney. Thank you. The attorney representing the management company. Now, this is also the attorney that represented my community association, the board. So a definite conflict of interest there. I did remove the complaint from my Facebook page and from theirs. Community management companies in Arizona do not have to be licensed. What does that mean to you as the public? You don't have anyone really to go to ask for help.
I don't know what else to say except for this cease and desist. These letters have caused me a lot of emotional stress. It's caused my husband emotional stress, my neighbors. It split our community in half. People don't know what to believe. Some want me to keep my furniture. Other ones say, well, you can't because the board says you can't. But again, there's nothing in the CC&Rs. It's really made me sick.
The pool deck hasn't been blown or swept in many, many months. In fact, I found a dead rabbit on the pool deck in an advanced stage of decomposition. I found the rabbit one day after her scheduled day to walk the property. You know, and then the board was putting out messages accusing me of killing the rabbit and dragging it onto the pool deck.
I see a Joey Bold and management companies telling me I can't do this or they'll sue me. And I say to myself, what a wonderful world. Got a letter from the board attorney telling me cease and desist because I disagree with the board and they got pissed. And I say to myself, what a wonderful world.